we are live on Facebook. So hello to everyone who is watching on Facebook. I can't see you, but you can see me. So welcome everybody who's joining us now on Zoom. And we still have some folks coming in. Welcome everyone. And this is part 2 in our special needs planning series of our NAMI forum. And I am Nicholas Amy. I am the Director of Outreach and Development here at NAMI Bucks County, PA. And NAMI is the nation's largest grassroots mental health organization dedicated to building better lives for the millions of Americans affected by mental health conditions. And here in Bucks County, we carry that mission out through no cost, recovery focused support, education, and advocacy. Our next event will be coming up in a month about personal financial planning, all the basics of financial planning that you need to know, and that's for everybody. So don't miss that. And tonight we're going to focus on maximizing the effectiveness of special needs legal planning for your disabled loved one. And we're joined by David Siegel. And before I introduce David, I'm going to let everyone know that you are welcome to submit questions in the chat. I will cue the questions throughout David's presentation, and toward the end, we'll save some time for Q&A. I'll also give you the opportunity to come off mic if you'd like, but right now, your mics and your video are disabled while we are in the presentation. So with that, and we have somebody else coming in. There we go. I'm going to read David's bio. So welcome everyone if you're just joining us, both on Zoom and on Facebook. I'm joined by David Siegel, and David is a licensed attorney. We have some more people joining. There we go. So David is a licensed attorney, and he focuses on estate planning, special needs planning, and elder law. Over the past decade, he has worked with families to help them plan for the long-term financial and legal success of their special needs loved ones. To that end, he has worked with families to set up special needs trusts and estate plans that incorporate all aspects of that life that will affect the family and the special needs person. He is well seasoned at the court process of petitioning the local counties for legal guardianships for incapacitated adults of all ages. He is licensed to practice law in both Pennsylvania and New Jersey, and practices primarily in Bucks, Montgomery, and the surrounding counties. And so I will hand it over to you, David. Thank you so much for joining us.
Thank you, Nick. Just to introduce myself, I am David Siegel, licensed in Pennsylvania and New Jersey. I've been invited here tonight by NAMI to speak to you about how to maximize the legal planning for disabled loved ones, whether they happen to be adults or minors. There's lots of different options that we can do, but we're going to focus primarily on a few tonight just for time purposes. I would like to state that all questions, and Nick's going to be filtering through them, if we can keep them more to the general question as opposed to something that's specific to you, that'll probably be better to help more people understand the situation. If you want to have a more in-depth conversation about your specific situation or matter, then we can do that offline as opposed to on this webinar. So first, I'm required to give you my disclosure statement. So a lawyer reading legalese. So this presentation contains general information only and is not intended to provide legal advice. This presentation does not establish an attorney-client relationship between the law office of David T. Siegel, LLC, and any of the attendees currently present or who receive materials from this presentation now or in the future. And for purposes of this presentation, I'll only be discussing Pennsylvania statute and Pennsylvania law. While I am licensed to practice in New Jersey, I'm going to assume that since we're talking to NAMI of Bucks County, that we're going to be primarily Pennsylvania focused. So just a quick overview of what we'll be discussing tonight. I have a little outline here that'll help everybody along. So first we'll go over the benefits of early planning. Early planning means something different to every person, every family. If it's a special needs loved one who is a minor, that's not too early. If it's someone who's elderly, still, the sooner the better for that planning. Then we'll actually get into the actual special needs legal planning. So first we'll talk about powers of attorney versus guardianships. Then we'll talk about special needs trusts, how to build a team to help you through the process, and then also coordination and communication, which is super important. And then finally, some next steps you can take to either establish or go forward with your own situation. So benefits of early planning. The benefits of early planning is very simple. It's about three main focuses. We want a preservation, protection, and preparation. It's the 3 Ps. The preservation is to maintain any public benefits that someone is currently receiving or may receive in the future. And we also want to maximize those public benefits. A lot of times there's situations where people are receiving public benefits, and the 2 big ones are going to be SSI, which is supplemental security income, and medical assistance, which a lot of people call Medicaid or MA. I'll be using all those terms. They all mean the same thing. But there's ways to maximize those benefits and get the most out of what the system offers, because it is an entitlement for the reason that you're entitled to it. Protection is all about making sure that there's advocacy, oversight, protection, making sure that the finances that you're leaving or plan to put aside for your special needs loved one is taken care of. There's lots of predators out there. When I was growing up back in the old days, the old situation was the vinyl siding salesman that would come and knock on your door and try to take grandma and grandpa's nest egg. Nowadays, the special needs community is the most hard hit by people who are con artists and predators trying to get into their finances because they're easy targets. And then preparation. We want to make sure that we can set up the independence and personal care for our special needs loved ones. So some common family concerns that I hear in my practice all the time: how to provide lifetime financial care, personal care, and advocacy for their family member; how to preserve the public benefits to meet current and future financial and healthcare needs; the ability to provide appropriate housing and caregiving for that loved one; the ability to maintain a person with disabilities independence; and then the biggest one is always, how do you replace the lost parents? In a lot of situations, it's the parents that are the primary caregivers. It's the parents who are the primary financial folks. It's the parents who are doing everything. When there's a lost parent, whether it's one, and especially when it's both, it could make a huge situation worse. It can put a strain on a family, could put a strain on a special needs loved one. It can make things very uncomfortable for everybody involved. So planning ahead, make sure that we can minimize the effects when we lose a parent. There we go. So the first thing we need to do is we need to gather as much personal information as we can about the disabled person's age and life expectancy. Life expectancy is more important than you would believe, because we have to plan for the long-term effect. If I'm planning for a special needs child with autism who's 12 years old, that person's going to live to be about 90. So we have to make sure that we understand that it's not just the next 5 or 10 years. It could be a lifetime that you and I won't be around to see the end of. We have to gather information on that person's disability. Is it unique to them? Is it something that there's a lot of different organizations like NAMI that are out there to help and provide advocacy? What's their legal capacity? This is going to become very important when we get into the power of attorney and guardianship part of tonight's talk. Getting together all the family members and friends who are willing to help. You don't know until you ask. A lot of times family members will step up and do things that you weren't expecting. So having that conversation, having that open communication with them is crucial to make sure that the plan survives. What is the current future living situation? Where is the person living? Where will they be living? What are your goals for where they're going to live? Are they going to live on their own? Are they going to live in a group situation? Are they going to live in a shared situation? All those things are important. What is that person's ability to work? This will affect SSI immensely. So the ability to work, the ability not to work, 2 things that'll come into play. Where are the person's assets and what is their income? Got to know where the money is, got to know how the money is being held, got to know in what form it's being held to make everything work properly. And then what are the current and future eligibilities to public benefits? Maintaining eligibility for public benefits is one of the key and crucial things that we do with special needs legal planning. One of the major things you might have heard about are the waivers. There's not a lot of them in Pennsylvania. So if you are going through the application process, or if you're already in it, or if you've already been approved, it's not something you want to leave. All right. So special needs legal planning. So here are the things not to do. And these are the 4 big ones that I hear all the time. The first one is to disinherit your special needs loved one. In that case, no money can legally be available for that child, because in most situations, people think, okay, if I disinherit them, they'll maximize their benefits. There's a way to maximize the benefits and not disinherit them. Leaving an outright inheritance. If you leave money directly to a special needs person who's on public benefits like SSI or Medicaid or medical assistance, they will lose it. So we got to make sure that we're planning ahead. Leaving assets to siblings who are going to care for the disabled loved one. I hear this so many times, and it's one of the biggest mistakes we try to avoid. By doing that, those assets are now subject to that sibling's creditors. When that sibling dies, those assets aren't necessarily going to go to your special needs family member. It might go to that sibling's children or spouse, etc. Assets, they could be lost to your sibling's creditors or bankruptcy. I've seen that too many times. And in the worst case scenario, that sibling's going to use the money for themselves. And then there's also people who leave assets to a non-qualifying special needs trust. And by non-qualifying special needs trust, they talk to an attorney or LegalZoom or any other organization, and they get a trust that's supposed to be a special needs trust, but it's not. And in that case, when they then let SSI and medical assistants know that they have a trust, it doesn't qualify as a special needs trust, and therefore they lose their benefits until that money is spent down. And we'll talk about the spend down in a little bit. And then there's also the possible loss of assets from mismanagement or fraud. These are all the negative things that can happen. So let's leave the negative behind and move on to the positives. So what are the 4 keys to special needs planning? And there's 4 keys right there. So let's go right to the first one, which, and we've had some questions already about this, power of attorney versus guardianship. This is about the who. Who's going to be acting on my special needs loved one's behalf when I no longer can, or once they're an adult. So we have to talk about the age 18. Age 18 is super important because at 18, a person is legally an adult. Whether they're incapacitated or not, they still are an adult under Pennsylvania and every state's jurisdiction law. And that individual is legally presumed to have full legal capacity to make their own financial and health care decisions. So at 18, whether or not your family member has special needs or is disabled, it doesn't matter. They're considered an adult, and doctors will ask you to leave the room. Financial institutions will not speak to you. Public benefits won't speak to you without your loved one telling them it's okay. So there are steps that have to be taken. The first is to begin the discussion about power of attorney versus guardianship. The second, of course, is post-educational transition. So at 18, transitioning from that high school, unless they're staying till 21, to the workforce or to an after-school care situation or an after-school training situation or an after-school work situation. Preparing for SSI, medical assistance, and other public benefits, because at 18, all those benefits change the way they look at your loved one. Under 18, they're still considered minors, and medical assistance gives everyone's eligible under the age of 18 to receive medical assistance if you meet the criteria. Above 18, they start looking at all the assets of the people that you're living with and the people around you and your income and all the other situations regarding that, and making sure that you're eligible is crucially important. We want to shelter any of those countable resources that are in that person's name. So 529s, bonds, cash, UTMAs, gifts, investment accounts, all those kind of financial situations have to be sheltered to make sure that the person still remains eligible to receive public benefits. And then also examining a special needs trust or a spend down option, depending on what the financial situation is at the time. I threw in a little definition on what a minor is. That's under Pennsylvania law, and the law is cited right there as my source material. So What is the biggest difference between a power of attorney and guardianship? It all comes down to one word: capacity versus incapacity. So 2 words. Capacity, under the legal definition, is the ability of an adult to effectively communicate and understand his or her financial resources and meet the essential requirements for his or her physical health and safety with minimal help from others. Effectively communicate and understand is underlined for a reason. That's what we're focusing on. If the person is nonverbal, if the person cannot effectively communicate their healthcare or financial needs, wants, and goals, they're considered to no longer have capacity, and we move down to the next step. If they do have capacity, then a power of attorney is sufficient to do all the things you need to do in that situation. If you are considered incapacitated under this definition, that an adult whose abilities to receive and evaluate information effectively and communicate decisions is in any way impaired, such that he or she is partially or totally unable to manage his or her financial resources or meet the essential requirements for his or her physical health and safety, they're considered incapacitated, and we're heading down the guardianship route. Anytime a client comes into my office and starts asking about power of attorney versus guardianship, this is where we start. What is that person's ability to effectively communicate? Are they impaired in any way, whether partially or totally? Because that'll help us move down the road to what is more appropriate for that person. In some cases, it might be a power of attorney. In some cases, we'll do a power of attorney, and then down the road, that power of attorney is no longer effective because of a change of circumstances. All those things have to be taken into account to make sure that the loved one is taken care of. So a power of attorney, like we've talked about, is for a person who is deemed to have capacity under the law. Then they may choose to assign the control and decision-making of their finances and healthcare to a trusted person for their benefit without court involvement. A power of attorney is the person giving away their power to make their healthcare and financial decisions. It's them choosing who's going to be making that decision for them. Whereas a guardianship, if a person is deemed to be incapacitated, the court determines that all lesser restrictive means, i.e. a power of attorney, would not be effective or were previously exhausted. A court shall declare the person a completely incapacitated person and shall appoint a person or persons who the court believes as the best choice to be the incapacitated person's legal guardian. So we're putting our trust and the fate of that person in the hands of the court. So sorry, just got distracted by a question, so I'm going to minimize that. There are 2 types of guardianship here in Pennsylvania. We have guardian of the person, who is responsible for the healthcare, custody, residential placement, and education of an incapacitated person. We also have guardian of the estate. They're in charge of the money and the legal situation for that person. So, sorry, I just lost the screen. Bear with me. There it is. We have a question here. Could you differentiate between medical and durable powers of attorney? Sure. A durable power of attorney can be both a medical and a financial power of attorney. Durable just means that it lasts throughout any incapacity. Medical is for medical, financial is for financial. A lot of times what you'll see is a general durable power of attorney is a financial power of attorney. Whereas here in Pennsylvania, a healthcare power of attorney is more specifically used for medical situations. You can have one person as both the guardian of the person, the guardian of the estate. You can have one person as both the healthcare power of attorney and the financial power of attorney, or you could have 2 people, or you could have one doing one job and one doing the other. So there's a lot of different options. It all depends on that situation and that family. So what are the bigger differences between them? So as you can see here, power of attorney is a private matter, whereas a guardianship is a public matter. It's a court proceeding, therefore it becomes part of the court record unless the party involved is a minor. With the power of attorney, the family will control the outcome and who the powers of attorney are. In a guardianship, it's all under the discretion of the court. The power of attorney obviously is less intrusive because it's something done privately without any court involvement, whereas a guardianship, we're digging into the person's life, the people's lives of the folks that are going to act as guardian. to the point where under Pennsylvania law, I'm required to do a criminal background check on all proposed guardians and present that to the court prior to the hearing. There's no recordings or accountings necessary under a power of attorney, whereas under a guardianship, you're required by state law to provide an annual accounting and recording for that person's healthcare and financial each year on the anniversary of the decree date. So a guardianship's obviously going to be a longer time commitment because you have to prepare and then you have to go to court. Whereas a power of attorney, you draft a document, you sign a document, and you're ready to go. And then, of course, there is always the cost matter. It's a large difference between what most attorneys, including myself, will charge for a power of attorney versus a court appearance, a legal guardianship, just because the amount of time involved. So what is a healthcare power of attorney? The general rule, the agent may act on the beneficiary's behalf, but not in lieu of that beneficiary's wishes. So the person, the beneficiary, the person you're acting for, the principal, they will have control of their own healthcare decisions. It's only when they are unable or unwilling to make those decisions does the power of attorney have the power to act. The biggest thing that most people who come to me for a power of attorney is just to have communication with the doctors. Once their loved ones over the age of 18, communication is huge. Therefore, the first time a doctor asks them to leave the examination room, they're stunned. So having that power of attorney in effect also provides HIPAA, which also provides communication legally. So who can have a power of attorney? The principal must be a person over the age of 18 or someone under the age of 18 who has graduated from high school or has married or is an emancipated minor. As long as the principal falls into one of those 4 categories, then a power of attorney is legally binding. The agent can be anyone over the age of 18. It doesn't have to be a parent, it doesn't have to be a sibling. It could be a friend, it could be someone you never heard of. Well, hopefully it's not, but it could be anyone who's over the age of 18 and is also a United States citizen. State citizenship and jurisdiction does not apply on powers of attorney. So if you have a loved one who lives out of state, you can still be their power of attorney. It just might make the communication a little different. It's not going to make it impossible. I think we're all used to doing Zooms and video conferencing these days. So having the electronic communication available, you can be power of attorney, live in California for a principal who lives in Florida. There's no restrictions saying that the power of attorney must also be in the jurisdiction that the principal's in. Where does this take place? Oh, sorry, what? The power of attorney provides the agents with the ability to act on the principal's behalf for all instructions regarding medical evaluations, treatments, and information. So again, this is only when the principal cannot or will not act on their own behalf does the power of attorney get to act. There is no court involvement. When it can happen, anytime after the principal turns 18 or any of the other situations that we talked about at the top. How is it done? The principal signs over the power of attorney to the agent in front of 2 witnesses and a notary public. As long as the document is witnessed and notarized, it's legally binding under Pennsylvania law. And then the limits are the same as the guardian of the person. And I'm going to go into those in more detail, so we'll get to that in a couple slides. The general durable power of attorney, a lot of people just think of as a financial power of attorney, but it actually handles everything in the principal's life outside of healthcare. So there is more to life than just finances. So as long as it's not falls under the healthcare category, the general durable power of attorney will last and be effective for that person. So again, the general rule is the agent may act on the beneficiary's behalf, but again, not in lieu of the beneficiary's wishes. The principal must be a person over the age of 18 for the general durable power of attorney. An agent also must be a person over the age of 18, but it could be anyone. It doesn't have to be a sibling, doesn't have to be a parent. As long as it's a person over 18, they're qualified to act. What does it do? It allows the agent to act on the principal's behalf for financial transactions and government benefits, as well as their legal matters. Where does it involve? No court involvement, because it's power of attorney, so it's a private situation that's done between you, your family, and the lawyer. When can it be done? Anytime after the principal turns 18, How is it accomplished? Again, it just has to be signed by the principal and the agent before 2 witnesses and a notary public. Once that's done under Pennsylvania law, it is considered legally binding. Sorry, I got to stop looking at the question. The limits, again, they're the same limitations as a guardian of the estate, which we're about to get to. So, guardianship. This is the court proceeding. The questions I hear about the most when it comes to guardianship is what can I do and what can I not do? So guardian of the person essentially is the guardian of the health care and residential placement. Your duties are to act in the best interest of the incapacitated person at all times. You're to advocate for the incapacitated person's rights and interests. Your job is to develop a plan of supportive services, and you're to encourage the incapacitated person to participate to the maximum extent of his or her abilities. The limitations is where people have some confusion, because I've had multiple questions from multiple clients asking, can I do this? Can I do that? Cannot means you cannot do it. It's against the law. It's not in the law that provides you the abilities to act under a guardianship. So the limitations are: cannot consent to sterilization, psychosurgery, electroshock therapy, experimental medical procedures, or the removal of a healthy organ without court approval. So it doesn't mean these things can't be done, but you're going before a judge to ask permission to have this done, and there are special circumstances for all the reasons to have these approved. You cannot prohibit that person from marrying or consent to a divorce on that person's behalf without court approval. So it doesn't mean that it's impossible. It just means that, again, you're going in front of a judge and a court to make sure they have approval on this. These are the things that you don't get court approval on. You cannot consent to admission to an inpatient psychiatric facility or state institution. You cannot involuntarily commit the person just because you're guardian. I'm going to let that sink in for a second, because that's the question I hear the most. Can I commit my loved one because of whatever their mental or emotional state happens to be? The answer is no. A guardianship does not give you the power under Pennsylvania law to have them involuntarily committed. You cannot consent to them relinquishing their parental rights. If that loved one has parental rights because they have children, you cannot consent to them relinquishing those rights. That has to go through a court proceeding. And then you cannot withhold life-preserving treatment unless the incapacitated person is in an end-stage medical condition or permanently unconscious, i.e. brain dead. So for end of life and do not resuscitate situations, just because you're acting as guardian, unless that person has signed a living will, you can't pull the plug on them just because they're incapacitated. And you cannot consent to an abortion except in emergency situations. So if there's medical need, that if the person is has a chance of not surviving, then in some cases an abortion is allowed. In other cases, it's not. Again, we're looking at asking for a court's permission for those kind of things, unless in the doctor's opinion it must be done. Guardian of the estate, so the guardian of the person's money. Your duties, again, are to act in the best interest of that incapacitated person at all times. You're to manage that incapacitated person's personal finances, including insurance, investments, banking, personal property. There are special rules for real estate, so leasing, buying, renting, selling, all those kind of things. There are special rules, but you are allowed to handle those and manage those. Your job is to develop a sound financial plan on that person's behalf. And in most cases, you may expend the incapacitated person's income without court approval. The biggest limitations are when it comes to the money is that you must use the standard of care that a person of ordinary prudence would practice in care of their own estate. It's known as the prudent investor rule. If you're not familiar with it, then I would say ask your financial advisor what the prudent investor rule all is about. But basically your job is to maintain those assets for the lifetime of the person for whom you have guardianship over. And you have to do that in such a manner that is more conservative than some people are comfortable with. You must manage the estate exclusively for the benefit of the incapacitated person. You are not allowed to profit or benefit financially from acting as guardian of the estate. So while guardian of the estate is a job, you don't get paid for it unless you're a professional guardian. The court would have to sign off on any situation where you're acting as guardian and also caregiver. They would have to sign off on you receiving a fee from that person's assets. And in certain cases, you must receive court approval for the distribution and use of the incapacitated person's principal and assets. So you can spend the income, you cannot spend the majority of the principal without court approval. That could be done with a simple petition to the court to ask for an expenditure, but it still has to go through the court system. Now we're going to jump into special needs trust, because that's primarily the other half of the special needs legal planning that I take care of. So what do special needs trusts provide? They provide the beneficiary long-term financial needs, protection of assets in the trust for long-term success. A special needs trust is a fully asset protected trust, meaning that the assets within the trust have full asset protection for the long-term stability and financial security of that person. They're to protect the beneficiary's eligibility to receive public benefits. When we go over to the public benefits in a little bit, you'll see that an individual is only allowed to have a certain amount of assets in their name only before they lose their benefits. It's $2,000. That's not a lot of money. So what a special needs trust does is it provides a quality of life fund so that the other things that public benefits don't prepare or pay for can be covered. And it does provide flexibility for the life of the beneficiary, because special needs trusts last as long as the beneficiary is alive. So there are two types of special needs trusts. The first is called a first party special needs trust. The first party special needs trust is established only by the individual, so the beneficiary, their parent, grandparent, guardian, or a court. There have been some certain circumstances where step parent, step grandparent, aunt, uncle is sometimes allowed, but we have to get court approval for that. A disabled person must be the only beneficiary. All these special needs trusts, whether it's this first party trust or the third party trust, which we're about to talk about, they are considered sole beneficiary trust, meaning there's one beneficiary. It must be a living trust, and it must be irrevocable. Irrevocable means exactly what irrevocable means. It cannot be amended, it cannot be restated, it cannot be revoked. And first party trust has a fun little caveat, which is called a Medicaid payback, meaning that if that person is receiving any Medicaid or medical assistance over the course of their lifetime, they have a lien. That lien is then called upon when they pass. The special needs trust is invaded to pay back the lien. So instead of those assets being distributed to heirs or other family members, the first people that get paid back is the Medicaid system. First party special needs trust is funded only with the assets of the beneficiary. It's funded by the first party. So where do those assets come from? In most cases, it's going to be litigation settlements, child support, divorce settlements, an inheritance that was left outright to that person. In life insurance or IRA distributions that are made outright to the beneficiary, all those things would qualify for being placed into a first party special needs trust. And you cannot fund a first party special needs trust with the assets of any other person but the beneficiary. You cannot use SSDI, which is Social Security Disability Income. You cannot use SSI, which is Supplemental Security Income. And veterans benefits can also not go into a special needs trust. Then we have the third party special needs trust. So the third party special needs trust is established by anyone except the beneficiary, thus a third party. The disabled or any other person can be the beneficiary. It can be a living or a testamentary trust. A living trust is a trust that is created during the life of the trust maker, the grantor, the person establishing the trust. As long as it's done during their lifetime, it's considered a living trust. If it is created after the grantor or the person who's establishing the trust's life, it's considered a testamentary trust because it's created after death. It can be revocable or irrevocable, meaning that a third-party special needs trust can remain revocable as long as the grantors are alive. So it can be amended to be flexible. It could be revoked if it's no longer needed. and there's no Medicaid payback. So when the primary beneficiary of the special needs trust passes away, instead of the assets being paid back to the Medicaid system, they go to heirs or other family members. It can be funded with the assets of anyone but the beneficiary. Most cases, that's going to be inheritance and lifetime contributions from the family and friends. Could be life insurance proceeds, IRA distributions. I don't recommend IRA distributions for tax purposes, but your financial advisor can fill you in on what those ramifications are. I let the tax people do the taxes. I do the legal work, but I'll tell you right now, all of them are going to say it's a death sentence to leave your taxed money into a special needs trust just because of the Secure Act. And you cannot be funded with the beneficiary's assets. So if there's any assets in the beneficiary's name, they don't go into a third-party special needs trust. So what can a special needs trust pay for? And I don't expect you to take a screenshot of this. And please don't try to read this all because I'm going to go fast. It's a lot easier to explain to you what it cannot pay for. So if the beneficiary is receiving SSI, supplemental security income, it cannot be used for food or shelter until the SSI is fully expunged for that month. If that person is receiving medical assistance, Medicaid, the special needs trust cannot be used for any procedure or medical situation that Medicaid or medical assistance would pay for. So again, there's 3 things that can't pay for depending on your situation. Everything else is on this list, meaning that it's a quality of life fund, meaning that it's there for the long-term care and, life experience of the beneficiary. Like that. And then there are ABLE accounts. These are fairly new. They came about in 2015, so we're looking at what, 7 years. An ABLE account really came from the disability advocacy groups that petitioned Congress and the Senate to create tax-free savings accounts just similar to 529s. So if you're familiar with 529 college savings plans, the ABLE account is actually coded as a 529A. It's a disability savings account. The criteria, it's a little strict. So you have to have been declared disabled prior to turning 26 years old. You must still meet the Social Security Administration's standard for disability. A disabled person is only allowed to have one ABLE account, and there is a Medicaid payback from all ABLE accounts, meaning that if that person is receiving medical assistance or Medicaid, the state Medicaid agency will be the first beneficiary to that ABLE account. What can it be used for? Any, air quotes, qualified disability expense. So what are those? So far, we know it's education, housing, transportation, food, and it's any other expenses later approved by the Secretary of the Treasury. There's a laundry list of things that it can do. There are certain things on here which you'll see, like the word food, which the Social Security Administration is not too happy about because SSI is supposed to cover food, and now ABLE accounts can cover food. So there's a little confusion when the law was written. The financial features are very simple. You're only allowed to contribute up to, well, this year it's $16,000 per year. Meaning that if there's an inheritance over 16,000, we can put the first 16,000 in an ABLE account, the rest would have to go elsewhere. Total contributions cannot exceed the state's limit for 529 plans, which under Pennsylvania is about $511,000. But at $16,000 a pop each year, to get to $511,000 is going to take a while to fully fund an ABLE account. And all contributions must be made using after-tax income, meaning that you pay your income tax on it, then you can contribute it to your ABLE account. Having an ABLE account will also affect your ability to receive SSI or medical assistance. If there's over $100,000 in your ABLE account, you lose SSI until it is spent down below $100,000. There is no amount of money that goes into an ABLE account which will affect your Medicaid or medical assistance eligibility. So that's pretty good. What are these benefits that I've been talking about? There are really 2 categories. There's needs-based benefits, which have income and asset limits. And the two big ones are supplemental security income, otherwise known as SSI, and Medicaid, or medical assistance. And that's your health insurance and employment support, et cetera. There are still entitlements that are public benefits where no income or asset test is needed. Those are SSDI, or as a lot of my clients say, just disability. There is an income test, but there's no income or asset test. There is Social Security. So just like when you turn 65 and you're eligible to receive Social Security, that is a public benefit. And there's Medicare, which is different from Medicaid. Medicare could be a primary insurance, could be a secondary insurance, but when you turn 65, you're eligible to receive it, and you pick your plan, and you make sure you do it within the time limit, otherwise you do get fined. There are other benefit programs that might come into play: Section 8 housing, veterans benefits, food stamps, the waiver services, etc. So let's talk about supplemental security income, SSI. As of 2022, the monthly benefit is up to $841 per month. You have to be categorically eligible, meaning you're either disabled or blind, or you're elderly, so over 65. You also must be financially eligible, meaning you have an asset limit of under $2,000. If you're married, $3,000. If you're low income, there's a certain formula we have to do. However, anything in a special needs trust is excluded from the eligibility on the financial side. So you could have $1 million in a special needs trust and still receive SSI. The $841 is only considered income for the 30 days that you have it in your account from the 1st of the month to the 30th of the month. Anything left in your account on the last day of the month becomes an asset and works against you on the asset limits. And depending on your reporting requirements for SSI, which could be, I've heard, monthly, quarterly, and annually, you don't want to get dinged for having too much assets, because they might require you either to pay back or they could suspend you for future benefits. And in most cases, if you're receiving SSI, it'll trigger the Medicaid eligibility, especially here in Pennsylvania. Medical assistance. It can be either a primary or secondary health insurance for disabled, low income, or high medical expense parties. You do need to be categorically eligible, meaning you're either disabled or blind or pregnant, which that's only in certain cases. You still have to have the financial eligibility of having less than $2,000 in assets. For married couples, 3. And then anything in a special needs trust is excluded from the financial eligibility. So again, you could have $1 million in a special needs trust and still get medical assistance to cover the medical bills. The benefits are, it covers all medical evaluations, procedures, long-term care facility costs, hospice, and if it's acting as your primary insurance, it covers dental, it covers prescription medications, it covers optical now. So it's a really big benefit that if you're receiving, you don't want to find yourself ineligible, because if you're suspended for even a month, that could be very expensive out of pocket. So now we're going to move to the next key to a special needs legal planning, which is building a team. Who's going to be the caretaker? The hardest question that I hear from clients all the time is, when I'm no longer here, who's going to take care of my special needs loved one? And a lot of times, and that's why I have a little man with stop sign, I hear, I want my other son or daughter to be caretaker of our children after us. They are family and will have the best of intentions for my special needs child when I'm no longer able to. That's a very unrealistic expectation. These people might love their family member, but they have lives and they have families. And in certain situations, they might have geographic obstacles. If they live in California, how do you take care of someone on a day-to-day basis in Pennsylvania? So understanding who that caretaker is going to be, whether it's going to be a person or an agency or family, is super critical. And then who's going to be the trustee if we decide to go the special needs trust route? Because a lot of times it's the same expectation that another child's going to be that trustee. Being a trustee is a job, not an honor. So let that sink in for a second. Before you hand someone this job of being trustee of a special needs trust, They have to be educated on how to be a trustee of a special needs trust. There are handbooks out there, and they're all good for the most part. But until you actually have to do it and see the time commitment involved in it, you really want to have a discussion with that person before you appoint them to be trustee. So, who is the ideal trustee? It's a person who will use discretion in the best interest of the disabled person. They must understand public benefit laws and keep up with the yearly changes in the benefits and the law, because that does happen on a yearly basis. They can wisely invest trust assets and make proper distributions of income and principal. They can conform to all statutory fiduciary requirements. They have a complete understanding of taxes and how trusts and disabled people are taxed. They can keep perfect books and records and a paper trail of communications. They can also provide advocacy and prevent abuse, and they understand the particular disability of the person and the costs and cares associated with having that disability. Oh, and by the way, it's really helpful if they're immortal, because they do have to outlive the beneficiary. Because again, a special needs trust dies when the beneficiary dies. So there is no ideal trustee. There's no one person who can do this all. Our goal is to surround the family with fiduciaries and professionals to help them throughout the disabled person's life. What is a fiduciary? Trustee is the big one. Successor trustees, guardians, executors, powers of attorney. Who are the professional helpers that we see the most? Care managers, advocates, therapists, doctors, financial advisors, attorneys, nurses, aides, teachers, nonprofit organizations. We want to surround that family with a ring of professionals and a ring of advocates that can help them take some of the burden and some of the job off their time. So what's the best way to do it? Split it up. Have an advocacy and care person, have a financial and trustee person, have an accountability person. Who those people could be, it's real simple. Advocacy, your care management, advocacy groups and therapists and doctors. Your financial, your advisor, your financial advisor, your accountant, your bank. Accountability, insurance, corporate fiduciaries. A lot of times there are a lot of financial advisors. I'm sorry, not a lot. There are a lot of trust companies, banks that are really good at being trustees, because A, they're licensed, bonded, and insured. B, they know what they're doing. Otherwise, they'd be out of business. So it takes a huge burden off of the family to know that they can have that service available to them. You just have to find the right one. So coordination and communication within the family is our fourth and final key. You want to avoid inheritances or gifts from parents, grandparents, and other family members going outright and directly to the beneficiary, because this can result in a loss or suspension of their public benefits. How do you do that? You want to review your estate plan. You want to review your insurance policies. You want to review your retirement plans. Make sure the beneficiary designations are not outright to your special needs loved one. You want to make sure that if there's a special needs trust set up, that trust is named as the beneficiary, especially life insurance. And then how much and what is being left to that special needs person, because that could go into tax consequences. How do you do it? You communicate. I know with my clients, I provide a letter that spells everything out, letting the family members know that a special needs trust has been set up and how to participate in gifting to that trust during life, at death, or even a long-term situation. You want to make sure inheritance and gifts go to the special needs person's trust as opposed to them outright. You want to make sure the family members that are going to contribute change their wording and not just say they're going to do it, but actually sit down and do it. And then you want to explain the reasons why this is important. And you can use my slides because that's why I'm sharing them. So what are your next steps? Early planning makes all the difference. The sooner you plan, the better you can be prepared. So you want to consider all potential future challenges to your plan and the beneficiary. So who's going to care for your loved one after you? Is it going to be a sibling, if that's possible? Is it going to be a facility? Is it going to be a care advocacy group? Is it going to be a care management agency? Who's going to do the work to care for them? Do you need a power of attorney or a guardianship? We go back to the beginning of the presentation on capacity versus incapacity. See where that person lies and then move forward in the proper direction. Do you need a special needs trust? In most cases, the answer is yes. In some cases, the answer is no. It's all going to depend on your particular situation. Not everyone needs one, but the people who do need one should have one. Who will be a fiduciary within the special needs trust and the plan? So who are the trustees? Who's going to act in those roles? Where and with whom will your loved one live? Is it going to be on their own? Is it going to be with a family member? Is it going to be at a shared living space? Is it going to be in a group home? Is it going to be at a facility? There's a lot of different options out there. Everything's particular to that person. What kind of lifestyle do you desire and what's available depending on the financial situation? What are the financial considerations that must be planned for? Is there SSI? Is there medical assistance? Is there excess assets? Are you planning on leaving a large inheritance or a large insurance policy or anything else where we need to plan around that? And does the person qualify for public benefits? If they don't qualify, why not? And how do we get them to qualify? And if you are currently on public benefits, how do you maintain the qualification for them? So you have to make a plan. You want to plan for long-term financial needs? You want to plan for a power of attorney versus guardianship? You want to plan on the living conditions? You want to cohort your family's estate plans and beneficiary designations? You want to meet with an attorney that specializes in special needs planning. A lot of folks can write a will. Not a lot of folks understand the nuances of a special needs trust. Vet the professionals you talk to. Vet me if you talk to me. You want to set up a proper special needs trust plan if applicable. And then you want to coordinate and communicate with the people that are going to be fiduciaries in your plan. Let them know that you put them down as trustee. Have that conversation. Have them speak to your financial advisor about what their responsibilities are going to be on the financial side. Have them speak to your attorney about what their legal responsibilities are. The idea is to plan, and it's never too early, and it's never too soon. So, Nick, if you're still there, now is a good time for questions.
I'm still here. And
I didn't put you to sleep.
No, definitely not. So there are a few questions, but I want to thank you first for being here and presenting. And that was a lot of information. And I don't know how you delivered it all without drinking any water. I didn't see, not once. So a few questions. Will there be an option for you to send me the PowerPoint and I can send it out to the folks who are interested, or do you want to do that directly?
No, I'll send it to you, and then that way you can distribute it to those people, those folks who reach out to NAMI.
Sure. All right. So just let me know. And Kathy, I can see that you want the PowerPoint, so I'll send it to you. But if you'd like it, let me know. A question about what happens if your loved one is restricted from benefits due to household income.
So would it be the person's household income or the income of the household in which they're residing?
I think it's the income in which the household they're residing and where they're residing. I'm trying to read other questions also. But
sure.
Christina, if you could clarify that for me. Yes. So the person's household income around them.
So what SSI, family income, not the person. Got it. So what SSI has is what it is considered in-kind support and maintenance. In a lot of situations, if the person is living at home with a parent or a sibling or a spouse, the spouse, parent, or family member's income is deemed to be theirs. If we're in a deeming situation, then there are ways to plan around it. It's just a matter of getting the unique situation based on the amount of money we're talking about. The in-kind support and maintenance is a penalty that SSI charges against you. So immediately of that $841 that you're entitled to, you lose 1/3 right off the top for in-kind support and maintenance. And then there's also a math formula based on the income on how that money is then reduced to zero. Because, and I don't mean this in a negative way, but it's going to come out negative. Public benefits give you just enough to stay poor. And if they don't have to give you a benefit, they're going to try not to. So there's a lot of situations where you have to work within the numbers of your individual situation to make sure that you can then have the person eligible. So I know that that's very generic, but again, a lot of these things become very matter specific.
Okay. Let me
I talk with my hands.
Okay. Let's go to can you move money in a 529 plan to a special needs trust?
So I believe that's a question for a financial advisor.
Okay.
As opposed to the attorney. As
Gotcha.
far as because I don't want to give financial advice. I'm a lawyer, and that falls under their purview. I know there's a way to convert money from a 529 to an ABLE account. And I know there's ways to convert money from a 529, but it's best if you have that conversation with a financial advisor.
Okay. And so Kathy asked that question. If you'd like me to connect you with 1847 Financial, just let me know and I can do that. Does the purchase of a house or condo or co-op count toward the asset restrictions for Medicaid and SSI?
No.
No.
So under the Social Security Administration's rules for both SSI and Medicaid, the individual is allowed to own one home as long as it is under a certain valuation point, which I believe right now, off the top of my head, is like $620,000 in equity. But you're allowed to own one residence and have it not count against your qualifications.
Okay.
You're also allowed to own one vehicle.
There you go. That was the other question. So there we go for that one. And I will send out the PowerPoints, absolutely. And Sharon wants to know, you mentioned shelter assets. If you could just
Christina doesn't have to quit her job, by the way.
You're too. Can you just clarify what shelter assets means?
Sheltering assets would be placing them into, like a special needs trust would be sheltering the assets from the Medicaid or SSI qualifications. There's sheltering assets for tax purposes, but that's not what I'm talking about in this instance. I'm talking about sheltering those assets so that the person can qualify to receive the public benefits, which is the main goal of a special needs trust.
Okay. And if Christina feels like she needs to quit her job, and maybe anybody else feels that way, what would you say to them?
Don't quit your job. There is a light at the end of the tunnel. There's ways around it. Not everyone's going to qualify for SSI. There's just certain people that don't make the qualifications. That's the way the system is set up. But in most instances, there is a way to work within the system to at least get a portion of the benefit entitled to.
Okay. Is the spending and access to the funds in a special needs trust discretionary? Is it completely discretionary? Or is there a limit to how much can be spent in a time period?
So okay, putting my lawyer brain on, because when you say discretionary distributions, that implies in my head that the beneficiary has the ability to make those distributions. And a special needs trust is a non-discretionary trust. It can only be used to supplement and not supplant the public benefits. Is there a yearly cap on distributions? No. So as long as the assets from a special needs trust are being used for the sole benefit of the primary beneficiary, then there is no asset or expenditure cap.
Okay. All right. I got through those. I'm just making sure.
Caroline said we missed her question.
That was the one I just asked. I just asked that,
okay,
Caroline,
cool.
and I just saw that too. Okay, PowerPoint, yes. What is the first step to apply for SSI?
You have to reach out to the county assistance office in your township. If you live near me, that'll be, so I'm in the Newtown area, so you're looking at Bristol. I know there's also another one up in Quakertown. So if you're more to the north central Bucks area, but your first step is to reach out to the county assistance office and begin the application process. And it is a long process that involves interviews and a full financial disclosure.
Yep. It's not the easiest process. Is there anyone who qualifies for both SSDI and SSI?
Yes.
Okay. If
There are people that are on both SSI and SSDI. SSI is based on your need of the benefit, whereas SSDI is based on your ability to work, your lack of ability to work based on a disability, usually around the job or with some kind of, usually, I'll use my lawyer words, so keep everything vague. Usually in that situation where it's either around a previous job or you at least have a job history, work history.
Have you ever set up a special needs trust for someone on SSDI?
You don't need to set up a special needs trust if you're on SSDI because, again, your income and asset levels don't count against you for SSDI. Have I set it up for people who are on SSDI? Sure, but there were other factors involved in that. So looking more towards the future as opposed to looking at the present. Yeah, we've set up for folks who are currently on SSDI, but might be on medical assistance or SSI in the future. So setting it up now as opposed to waiting till after the fact.
Okay. If there is a power of attorney, can't the person who is giving up the power cancel it?
Yes, a power of attorney is both amendable and revocable, meaning that let's say I have power of attorney over my daughter because she's going to college. So she's going to college and I have power of attorney to act on her behalf if she cannot or will not act on her own behalf. At any time in writing, she can revoke that power of attorney or she can remove me as her power of attorney. So powers of attorney, one of the negative, well, it's not a negative because if you're the person who's the principal, it's positive. But one of the situations with having a power of attorney is it is amendable, it is revocable. The person can remove an agent, both agents, all the agents, and choose a new agent.
Okay. I think I got that one. My son is 25 and qualified for Medicaid due to his disability. He doesn't qualify for SSI now, but may in the future. Does his current disability qualification last for a later time? I think we might want to get a government specialist on. I think
Yeah.
Brian had that idea, but the question was, if her son is 25 and qualified for Medicaid due to his disability, he doesn't qualify for SSI now, but he might in the future. Does his current disability qualification last for a later time? Like, does this current disability qualification follow him through to a point where he might need SSI?
As long as that disability qualification is still in effect.
Okay.
Then it won't affect the future. Again, the SSI, if you have the disability qualification but don't have the asset income qualifications, that's probably what's blocking it in this case. I'm taking a guess here. But if that were to change in the future, just as long as the disability qualification is maintained and still eligible, it should qualify at a later time.
Okay. Is there a way to ration payments to the special needs person who may spend unintentionally or unwisely from the trust? Is there any way to have a bank or trustee limit the amount available at any one time? For example, if someone was manic and would spend destructively.
So this all goes back to one of the things that I don't think I brought up in my talk, but is important to understand about a special needs trust. A special needs trust is for the benefit of the beneficiary. It is not the beneficiary's money. Therefore, they should not have access to the money in a special needs trust. If they do, it breaks the whole reason that a special needs trust was set up, and they can be disqualified from public benefits if that's found. So the big key to remember with special needs trusts, which I'm sorry I didn't put in the presentation, is that it's not an ATM for the disabled person. While it's for their benefit, it's not their money. The only time that it is considered their money is even in a first party trust where the money came from them. It's still now considered the trust's money, and therefore the trustee has full authority on how those distributions of income and principal are going to be made. So would a bank acting as trustee have the ability to limit the amount of money? Sure. As long as they're acting in a fiduciary capacity, which is acting in the best benefit of the beneficiary. So if the person is a spendthrift or has destructive spending habits, limiting their access to the funds would fall squarely within that fiduciary role.
Okay. And I think that's every question that was submitted.
Awesome.
And if anybody has any others, it's now is the time. But I'd like to thank you again, David. That was great.
Thank you. So I just want to thank everybody for showing up tonight and listening to me prattle on. I have my contact information up here if anyone wants to reach out at any time. And then, of course, I will give the slides to Nick, who can then share them with everybody who registered or who showed up. It's up to you guys.
I'll send it to everyone who registered just in case. Because I know folks will watch along. I had a lot of emails from folks who are going to watch along later on. So I'll send it out to everyone who registered for this session.
Great.
All right.
Okay. Well, everybody have a good night and a good weekend.